Good evening, everyone. I'm Professor Michelle Foster, and I'm the Dean of the Melbourne Law School, and it's my great pleasure to warmly welcome you to the 2024 Miegunyah Distinguished Visiting Fellow Lecture. I'd like to begin by acknowledging that we're meeting this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to Elders past, present and emerging. And I extend this acknowledgement to any Aboriginal and Torres Strait Islander peoples joining us today. Well, tonight's lecture is part of a program that includes a fellowship to support a distinguished academic from an overseas institution to spend time at the University of Melbourne and collaborate and contribute to our vibrant academic community. The Miegunyah Distinguished Visiting Fellowship Fund was established in 1993 through the bequest of Sir Russell Grimwade. The Fellowship Fund is one of many extraordinary contributions made by the Russell and Mabe Grimwade Miegunyah Fund to the University of Melbourne, and by extension to the City of Melbourne, to which the Grimwades have contributed so greatly. Alongside this fellowship, the bequest included an extensive art collection, now housed in the Ian Potter Museum of Art, in our university archives and at the Baillieu Library here on campus, as well as funding the nationally significant Melbourne University Press and the Miegunyah International Scholarship. And we're thrilled to welcome Angus Grimwade, who is here with us tonight. He's the patron and head of the Russell and Mabe Grimwade Miegunyah Fund, and it's just wonderful to have you here tonight, Angus. The 2024 Miegunyah Distinguished Visiting Fellow is Professor Shazia Chowdhury. Professor Chowdhury is Professor of Law at Oxford University and Geoffrey Hackney Tutorial Fellow in Law at Wadham College. She's also an Associate Academic Fellow and Academic Bencher of the Inner Temple. Professor Chowdhury's research focuses on European and UK human rights law and the intersection of those rights with criminal, family and human rights. Professor Chowdhury has advised the UK Government on the Joint Parliamentary Committee on Human Rights Inquiry into Violence Against Women, the Joint Committee on the Draft Domestic Abuse Bill and the Women and Equalities Committee. She's also advised the European Commission, the Council of Europe and the UN and in its Sexual and Reproductive Health Agency, UNFPA. This year, she was put forward as the UK Government's first ever nomination for the UN Committee on the Elimination of Discrimination Against Women. Tonight, her presentation is entitled Human Rights, Domestic Violence and the Family Law System, the Continuance of the Public-Private Divide. Following Professor Chowdhury's presentation, there will hopefully be time for Q&A, so please save up your questions and be ready to put them to the Professor after her presentation. And my law school colleague, Professor Heather Douglas, will moderate this Q&A session. Professor Douglas is herself an eminent scholar and teacher and is currently Deputy Director of the ARC Centre of Excellence for the Elimination of Violence Against Women here at Melbourne Law School. Tonight's proceedings are being recorded and the recording will be made available on the Melbourne Law School website shortly. But now, without further ado, it's my great pleasure to hand over to the 2024 Miegunyah Distinguished Visiting Fellow, Professor Shazia Chowdhury.
Thank you very much, and thank you very much for that lovely introduction, and especially to Melbourne Law School for making my first visit to Australia happen, and also to Professor Heather Douglas for all the work that she put in getting me here, which is very much appreciated. So as the title of the lecture indicates, I'm going to talk about human rights, the family justice system and domestic abuse. But first of all, sort of find the clicker. How do we actually access our human rights? So we talk quite a lot about human rights law, conventions. I'm sure lots of you have heard about various conventions, in particular CEDAW, which has just been referred to. So how do we actually realise our human rights on the ground, as it were? And in order to think about that, I just want to introduce you to the concept of performativity. The concept of performativity is most often associated with an academic called Judith Butler, and her articulation of performativity has been applied in a wide variety of contexts and disciplines, but not least because it enables us to consider the political and social forces that construct and normalise legal and political practice. A performative is defined, as she puts it, as that discursive practice that enacts or produces that which it names. So to give an example within family law, a declaration that a couple is now married or indeed divorced is an example of this, because the declaration itself brings about the change in the status of the couple without any lapse in time. This analysis has also been applied to human rights discourse. Janet Zignon has argued that in contrast to the declaration of the inherent existence of human rights found in the preamble to the UN Declaration on Human Rights, it is the recognition of that inherence that provides the grounds for human rights. As a result, when when inherence words in the UDHR such as dignity, inalienability, etc. are referenced, cited and repeated in by other documents and actors, this results in a performative iteration that works to lend legitimacy and authority to an international legal system. So we bring human rights into being by performing this iteration and this performance of description and repetition and citation. There are a number of requirements that are needed to bring and maintain this so-called truth of the global morality of human rights. And in doing so, she notes the necessity of the state, first of all, as being the constantive guarantor in this process. And the state is the guarantor in this process in terms of every subsequent recital of the UDHR preamble, and it addresses either the relationship between the state and individuals or states with one another, and provides human rights with actual and practical effect in the world. It is also necessary to maintain this truth once human rights are practiced in the world. This, Zignon posits, is achieved in two ways. First, by the continuous reaffirmation of the coexistence of human rights and dignity in each utterance of this link. And second, the truth of human rights and dignity in the world is achieved, she says, by the manifestation of this truth, by institutions, groups, and individuals who provide services or mobilise political action in the name of human rights and dignity. This effect is in turn given force by so-called felicity conditions provided by the flow of international funding, media support, and international governmental rhetoric and policy aimed at maintaining this moral truth of human rights. In this way, she argues, the foundation of the global human rights system, the UDHR, was a result of a performative, constitutive manoeuvre which brought into being the foundational truth of human rights. Significantly, within this process of repetition or iteration, and more precisely in the gaps that exist between the intended and actual effects of language, lies the opportunity to alter the understanding or effects of language. And this has been of particular interest to those of us who are utilising a feminist interpretation of the law. Repetition, therefore, is not exact replication. It can be deployed in new ways, in ways that displace the original meaning of a word or a norm, changing the way that we think or act. And this analysis has been applied by Karen Zeevy to the political practice of rights claiming, and in particular to the notion of women's human rights. She argues, in using the authoritative discourse of human rights, which traditionally excluded women from the understanding of the human in human rights, they are not simply suggesting their inclusion into the understanding of human, but instead are challenging us to rethink the meaning of the human, exposing the conventional limitations, as she argues, of the human while challenging its universality. Butler has termed this perverse reiteration, and that's what that essentially is an unconventional formulation of the universal that not only reveals the limitations and exclusivity of the universal, but also mobilises a new set of demands. So rights claiming by women and other traditionally excluded groups therefore entails a double movement, not simply a citation of liberal norms, but also their transformation. And this perverse reiteration and the transformation of this concept of human rights can be illustrated by, I would argue, the success of the women's human rights movement, which I'll go into next. So how did women's rights become human rights? I'm sure you've all heard this slogan before. Well, we know that women's rights largely fell off the mainstream human rights agenda for more than 40 years following the adoption of the UDHR. Therefore, the foundational truth of human rights at this stage was still based on a set of liberal norms that privileged the realities of men's lives and the marginalisation of women. And that was until the mid-1980s and 1990s, when feminist scholarship began to interrogate the absence of women from international human rights law by either arguing for doctrinal inclusion or conducting structural bias critiques of international law, which sought to identify a series of dichotomies that perpetuated the inability of the international human rights system to cater for women. The most significant of those dichotomies was the public-private distinction, the liberal norm, or the liberal notion that the public sphere should not interfere with the private realm. Now, of course, family law is very much within the private realm, and these feminist critiques of the public-private distinction also serve as a connection to the recognition of the performativity of rights that subsequently took place. So by using the established and authorised discourse and norms of liberalism, feminists made new claims, women's human rights, through the process of perverse reiteration, challenging the international human rights community to rethink the meaning of human and exposing its limitations in its failure to reflect the realities of women's lives. And in this way, feminists opened up the gap between the foundational norms of human rights discourse and their effects and exploited the potential for political agency, dislodging human rights from its original context and re-signifying the meaning of the term. So as a result of that, we see in the mid-1980s women activists beginning to question the ghettoisation of women's rights by the institutional separation of women's rights and human rights, and the UN Commission on the Status of Women. This recognition of the fact that women's lives were not the outcome of individual private choices, but subject to systematic patriarchal oppression, was illustrated by the iconic rallying slogan, "The personal is political." In other words, the private realm represented oppression and the manifestation of the divide in the everyday lives of women. And the effect of this was significant. Each utterance of the slogan, "Personal is political," resulted in a performative iteration of the link between the public and private lives of women. And today, the continuous reaffirmation of this link serves to maintain its truth. However, the manifestation of this truth is only made possible via the continuation of certain holistic conditions, such as the flow of donations to fund campaigns and lobbying, media support, and the mobilisation of legal and policy developments. The feminist rejection of the public-private divide has been particularly significant to the issue of violence against women and was integral to the success of the global campaign for women's human rights, in framing violence against women as a human rights issue in of itself. The slogan, "Women's rights are human rights," became a powerful call for the inclusion of women as full subjects of international human rights law and achieved considerable success. In 1992, the UN Committee for the Elimination of All Forms of Discrimination Against Women, CEDAW, adopted General Recommendation 19, which expressly links discrimination and violence and laid down a framework on violence against women and confirmed the need for states to take positive measures to eliminate violence against women. Consequently, in 1994, the UN Commission on Human Rights appointed the first special rapporteur on violence against women, and the UN issued the General Declaration on Elimination against Violence against Women, which states that three forms of violence may constitute violations of women's human rights, and that includes violence in the family. As a result, we have a new international norm that violence against women is a human rights violation, and this has been concretely adopted in relation to the optional protocol to CEDAW and in relation to a number of UN resolutions and declarations that have happened ever since then. Subsequent case law of the CEDAW Committee under the optional protocol also confirms the engagement of a state's responsibility for violence against women as an international legal norm. So it's very clear, therefore, that all states who have signed up to CEDAW have a responsibility to eradicate violence against women, and particularly within family law. So the international legal and policy framework has therefore been accompanied by an adoption of various legal and policy frameworks at the regional level. And there are now 2 regional conventions directed solely at eliminating violence against women. We have the Inter-American Convention, and we also have the Council of Europe Convention on Violence Against Women in addition. We also have an increasing body of jurisprudence on violence against women under these regional instruments. As a result of that, we can see that there's been quite a high level, as Butler would put it, of performativity at the international and regional level in terms of women's human rights. And that's been achieved by the transformation of human rights norms in a process of double movement. The meanings of human and due diligence were successfully challenged through a process of perverse reiteration in order to rethink their meaning and expose their limitations in reflecting the experiences of women victims of violence. This bringing into being of the existence of women's human rights was further cemented by the recognition of the constantive guarantor, that is, international and regional human rights institutions, courts and state authorities, to ensure that these rights have actual and practical effect in the world via the establishment of new legal norms and principles that should be applied by courts also at the domestic level. So it's a sort of whistle-stop tour through the development of international human rights norms in relation to women's rights, but in particular how we now have come to a position really where we're quite a strong position of having quite a number of norms being established in relation to state responsibility to eradicate violence against women. So one might ask, how is this relevant to family law? Well, I've kind of answered that already, in the sense that family law is very much seen as part of the private realm and has been, well, since time immemorial, really. And this is one of the issues that feminists were particularly concerned about, particularly within family law, which is busting open this divide, as it were, in terms of the public and private realm. So the idea is obviously that there is no area of law that can avoid these obligations in terms of human rights, and that includes family law. So I just want to look through very quickly some issues that have been quite important in terms of why this is an area that we need to consider in terms of human rights. And the first issue there is, I'll come back to these particular issues later on in the lecture, but I just want to go through a few of them before I talk about how international human rights law has actually tried to address some of these problems. But see, these are some of the problems that we are aware of and why we think that human rights law actually should be relevant to family law. The first one is that we know that domestic abuse is one of the most serious and pervasive forms of violence against women and girls and constitutes a violation of their human rights, thanks to the systems that we now have in place and the understandings that we have in place. The second is that the prevalence of domestic abuse in and around separation in particular, as being the most dangerous period for a victim, has meant that there are particular dangers posed by post-separation contact for adults and children when they leave violent and abusive relationships. So as we know, unfortunately, all over the world, when women and children do leave an abusive relationship, they are at a higher risk of homicide. And we see time and time again that unfortunately happening. So the risks are very high, and the consequences are very serious if family courts get this wrong. Thirdly, the phenomenon of domestic abuse perpetrators using family law proceedings as a tool to continue the abuse and coercion is also something that researchers are also aware of. We now understand that domestic abuse is rarely about the abuse. In fact, it is about coercion and control. And we now know that perpetrators of domestic abuse will use family law proceedings as a way to continue that coercion, even though the victim has left the relationship. This secondary traumatisation, because that is effectively what it is when that happens, implicates, I think, state institutions in its perpetuation and therefore engages a state's responsibility in terms of its due diligence obligations to avoid this happening in the first place, particularly when we see domestic family courts granting access and custody to perpetrators of domestic abuse, even where there is evidence of domestic abuse happening. And in recent years, the concept of parental alienation has played a significant role in providing justifications for such outcomes, causing widespread alarm and distress, to the extent that the current UN Rapporteur on Violence Against Women and Girls, has just issued a global report on the impact of parental alienation on access and custody outcomes. So it's an issue that we are all very, very concerned about within this field. So going back to international law, what has been the response? I gave you a kind of outline of the international human rights law, why women's human rights are indeed human rights, what it took to get there, but there has been a response from the international legal mechanisms to this issue. I just talked about one of them. The UN Rapporteur has a mandate, and she's produced this report on this issue. But there's also been lots of other action that's been taken in relation to, from international law. First of all, international law recognises a state's obligation to adhere to a standard of due diligence, as it's called, when addressing violence against women. And that consists of 4 important obligations on a state. So any state party that signs up to CEDAW has these obligations: to prevent, to investigate, to prosecute, and to provide compensation in relation to violence against women. In addition to that, the CEDAW Committee adopts general recommendations based on its analysis of the Convention, and identifies in the reporting process for each state and in its procedures under the optional protocol a number of comments and recommendations. And these recommendations give authoritative guidance to states to follow. General recommendation number 33 was aimed at supporting state parties and other stakeholders to establish, maintain and monitor well-functioning justice systems. And these systems are to basically conduct these investigations in a gender-sensitive manner. This includes remedies and also gender-sensitive data collection and gender-sensitive analysis of the data that is collected. What we know from CEDAW under this particular recommendation is that we need critical gender analysis of decisions rendered, and that includes judicial proceedings, authorities involved, the participation of women in them, and the legal reasoning followed and assumptions made. So there ought to be monitoring of all judicial decisions that have taken place that affect women in particular under this recommendation. In addition, the committee has also made it clear that it's the state's responsibility to appropriately address their consideration of the specific needs of women and children in determining child custody in cases involving gender-based violence in the domestic sphere. And that's in Article 5 of the Convention itself. Moreover, in 2014, the committee recommended that any history of domestic violence and abuse must be considered when determining visitation schedules to ensure that these do not endanger women or children. Since then, the committee has issued a number of concluding observations when it directs state parties to abolish various problematic procedures, but also in relation to the concept of parental alienation. There have been specific comments based on this from the committee. And there have been a number of examples from New Zealand, Italy, etc., where they have referred to the problematic use of parental alienation and the need to conduct compulsory judicial training on domestic violence, including on the effect that exposure to domestic violence has on children. Most importantly, the committee has consistently recognised the implications of such practices for the human rights of women and children, victims of violence, and the need to prioritise those over the rights of perpetrators in such proceedings. And in its 2017 update to General Recommendation 19, they expressly included this issue, as you can see from the quote there. Perpetrators or alleged perpetrators' rights or claims during and after judicial proceedings, including with respect to property, privacy, child custody, access, contact and visitation, should be determined in the light of women's and children's human rights to life and physical, sexual and psychological integrity, and guided by the principle of the best interest of the child. So it's very clear from the work of CEDAW how important the question of human rights is to the question of what happens within the family court system, particularly in relation to victims of domestic violence, including both children and adults, which are in most cases women. Such issues also directly concern the rights of children. We also have the UN Convention on the Rights of the Child. Article 12 provides for the child who is capable of forming their own views the right to express those views freely in all matters affecting them, and for their views to be given due weight in accordance with their age and maturity. It also provides them with an opportunity to be heard in any judicial proceedings. Article 19 also provides that the right for the child should be protected from all forms of physical or mental violence, injury, etc. And where it occurs, the failure to address intimate partner violence and violence against children in custody rights and visitation decisions is a form of violence against women and their children, and a violation of the human rights to life and security that could amount to torture. This has all been held within the purview of the UN Committee on the Rights of the Child. It also violates the best interests of the child legal standard. There are also a number of general comments that are particularly relevant to family law cases concerning the right of the child to be heard, to be free from violence, and to have their best interest taken as the primary consideration. We also have a number of regional mechanisms and regional human rights treaties which have also specifically addressed this issue. Article 31 and Article 45 of the Istanbul Convention require judicial authorities to not issue contact orders without considering incidents of violence against the non-abusive carer as much as against the child itself, and to impose sanctions which are effective, proportionate and dissuasive. In its monitoring activity to date, the monitoring body of the Istanbul Convention, which is called GREVIO, has described at length and brought to light state parties' strengths and weaknesses in the implementation of these articles with regards to victims of domestic abuse and decisions made on custody and visitation. And in particular, they are very concerned about the widespread use of the pseudo-scientific concept of parental alienation as a means of minimising evidence of domestic abuse. Furthermore, the European Convention on Human Rights and the European Court of Human Rights has recognised on a number of occasions now that domestic violence and the impact of it on women and children comes within the scope of a number of articles under the Convention, some of which are absolute, such as the right to life and the right to be free from inhuman and torturous and degrading treatment. We also have the Inter-American Model Law on the Prevention, Punishment and Eradication of the Gender-Related Killing of Women and Girls, Article 10. And we also have Article 7 of the Belém de Pará Convention, which also obliges state parties to condemn all forms of violence against women, and that includes in relation to the family justice system. Finally, the protocol to the African Charter on Human and People's Rights, the Maputo Protocol, at its Article 7, explicitly affirms that in case of separation, divorce, or annulment of marriage, women and men should have reciprocal rights and responsibilities towards their children, and in any case, the interests of the children should be given paramount importance. There haven't been any cases in relation to this specifically before the protocol, but you can see, therefore, again, with that whistle-stop tour through the human rights system, that there are a number of provisions that are clearly relevant to the question of domestic violence allegations in the family justice system. And you can also see a clear set of obligations that have been established by various international human rights mechanisms and courts in relation to state obligations. So states are not supposed to just sort of stand by and let domestic courts do what they like. They're actually supposed to be positively intervening in terms of their positive obligations to create a situation where we prevent further domestic abuse and we prevent further harm being meted out to existing victims of domestic abuse. And as we shall soon see, unfortunately, that hasn't really happened. I just want to briefly mention the Hague Convention also. This is a multilateral treaty, which is another sort of tool in the international human rights box, which has been used to varying effect, but it's important to recognise this one in addition. This treaty seeks to protect children from the harmful effects of abduction, and essentially, when state parties sign it, they agree to return, if a child has been abducted, to return the child to the country of origin, and that court will then deal with the question that's before them. The basis of the convention is the best interest standard, which is not a huge surprise. However, there is an exception to the return of a child. There are a few exceptions, and one of them is where there's a grave risk that the return would expose the child to a physical or psychological harm or otherwise place the child in an intolerable situation. And what we're seeing, and I'll talk about that later on, is that there is a real gendered impact to the Hague Convention. We see a lot of women abducting their children back to their home country precisely because they are victims of domestic abuse. And what happens is that they are then forced to return their children. And so really it's a question of whether or not the domestic courts are willing to use the grave risk exception that's there under the Hague Convention. And we can see it's quite a mixed picture, actually, in terms of doing so. New Zealand seems to be doing quite well on this. There have been a couple of cases recently where they have interpreted the grave risk exception to include a risk of domestic abuse, but quite a lot of states are not doing that. And so there's a bit of a campaign going on in relation to some activists trying to get the Hague Convention to be amended to make it very explicit that domestic abuse ought to be a particular exception to this rule. So that's the sort of box, as it were, toolbox that's available to us, and isn't it brilliant? It should be. A huge amount of work has gone into it, not least from academics, but also from activists. You know, that's why we have this women's human rights movement. It's, you know, it's by women, for women, and it should be being used. But what's going on the ground? Let's see. Well, what I want to look at now is the nexus between the gendered nature of the family law arena and domestic abuse. So I want you to try and hold, if you can, all that in your head in relation to that's what we're supposed to be doing. This is, you know, a huge amount of, you know, work that's been done. We've got this really great toolbox that we should be using, but what's going on the ground? So we can see from what I've just set out that a number of international and regional mechanisms have recognised the need to ensure that post-separation access and custody, where domestic violence is present, is subject to thorough risk assessment, and that the wishes and feelings of children are heard when family courts are deciding what outcome represents the best interest of the child. There's also been a substantial degree of concern and engagement on the nexus between custody and access cases, violence against women and children, and a widespread acknowledgement of the abuse of the concept of parental alienation and related concepts. This engagement has resulted in a substantial body of recommendations, case law and positive obligations in this regard. And what I want to do now is just run through, again fairly quickly, quite a large amount of research. I should add there's a huge amount of research on this, and a huge number of academics are working on this at any one point in time all over the world. And I'm going to summarise some of the key issues that have come up from the research. This is all evidence-based work. Right, so first of all, what do we know about domestic abuse? Well, we know it's a gendered phenomenon. We know that most victims are women and girls. And whilst men can also be victims of domestic abuse, women are at a much higher risk of experiencing domestic violence abuse, and the dynamics of abuse are often very different for male victims. The causes of domestic abuse are complex, But we do know that gender inequality and the unequal distribution of power between men and women plays a significant contributing factor. And I'm going to use the P word, which I try to do at any point in time, the patriarchy. Let's not forget about that. Second of all, we know that domestic abuse features heavily in applications made to family courts, particularly where it's actually very difficult to get into the family courts. In the UK, for example, we took away family legal aid from all family law proceedings, and the only way that you can get legal aid is if you can prove that you were a victim of domestic abuse, and it's quite a high threshold. As a result, there's quite a lot of domestic abuse that comes before the family courts. That does not mean, however, as some lawyers seem to interpret it, that women are making it up in order to get legal aid. It means that it's much more likely, therefore, that you will end up before a court. And of course, if there's domestic abuse, it's going to be contested. So of course, it's going to be much more likely to end up in front of the family courts. But we see this sort of bizarre reaction to this, which seems to suggest that women are just kind of making it up to get legal aid, which I always find really odd. But anyway, we do know that there is some data, and the data that we have, for example, in England and Wales, we know that the prevalence of domestic abuse in these cases is considerably higher than in the general population, with allegations or findings of domestic abuse in samples of child contact cases ranging from 49% to 62% of cases that come before the English family courts. And in the vast majority of cases, the alleged or proven perpetrator was the father. So that's what we do know from the data that we've got. So there's a high prevalence of domestic abuse. The perpetrators are often the fathers, and there's a high prevalence of domestic abuse that comes before the family court. We also know that most, if not all, family law systems have incorporated the best interests of the child standard in making decisions related to custody and access, in accordance, obviously, with international standards on children's rights, not least the UN Convention on the Rights of the Child, which I talked about earlier. The best interest standard has, however, resulted in a general culture amongst evaluators, and these are the court-appointed experts that are there to help the court make its decision, that contact between a child and both parents is to be prioritised and is generally a good thing, even where, however, evidence of domestic abuse is present. And underpinning these attitudes is what's been termed the good enough father approach, that fathers are necessary regardless of their behaviours, including violence. And this leads to the minimisation of violence as an important factor in the evaluation of the best interest standard and the negation of the wishes and feelings of the child when he or she expresses a wish not to see the abusive parent. It also leads to problematic attitudes towards protective mothers because contact is seen as undeniably beneficial for children. Mothers who oppose or seek to restrict contact or raise concerns about it are widely regarded by evaluators as obstructive or indeed even malicious. And this is evidence from focus groups and lots of qualitative research that's taken place amongst survivors of domestic abuse who've been through the judicial process. Evaluators, it has been therefore, have thus contributed, unfortunately, to pervasive ideology of mother blaming, in that mothers are held accountable even when their partners are violent towards their children. And this is a phenomenon that has been increasingly recognised in the research evidence to date. We also know that from research that allegations of intimate partner violence tend to receive insufficient scrutiny and trigger problematic assumptions about patriarchal violence, such as the myths that domestic violence causes little harm to the mother or child, and that shared parenting is an appropriate goal in situations of family violence, and that domestic violence ceases with separation. There's a really great analysis from somebody called Marianne Hester, who is absolutely brilliant, and it's called the 3 planets analysis, which I think is a really great way of demonstrating really what the problem is when it comes to the family justice system. And she's analysed this problem in terms of planets. It's called the 3 planets analysis. So she says, if you're a victim of domestic abuse and you have children, through the 3 planets will become involved with you. The first one is the criminal justice planet. Perhaps he's arrested, perhaps he's been charged. He will be put on bail, and the conditions of that bail are that you are not to allow any contact between him and the children. So that's the criminal justice planet's response, and here you are as the mother of these children. Then you have the child protection planet, and the child protection planet may become involved as well, because this may be regarded as well, it clearly is abuse, but in terms of failure to protect, etc. And again, the message from the child protection planet is you must not allow contact between the children and the perpetrator, because if you do so, it's evidence of a failure to protect. And then you have the family justice planet. And what's that telling the mother to do? That planet is saying contact is in the best interest of the child. It's something that we encourage, and we should be allowing contact. So the first question that the family court often consider is, how do we make contact happen? Rather than thinking, is contact safe? Is there a risk assessment that we need to be doing here? And then how do we make contact happen if it is considered to be safe? But what we know from the enormity of research that's covered in this area, that actually the question that the family court often asks, first of all, is how do we make contact happen? And this is what's been termed a contact at all costs culture. So you can see from this very, I think, simple but very powerful analysis, the binds that we are placing protective mothers in terms of what we're actually asking them to do, which is to not do it in relation to the criminal justice planet and the child protection planet, but then you've got the family justice planet, which is putting a huge amount of pressure on her to make contact happen. And also, I might add, to put aside her own traumatic experiences of domestic abuse and go through quite stressful judicial proceedings. And this includes also the children, of course. So mothers are held accountable, and I've just done a piece of research involving 6 European jurisdictions and spoken to women from all of those jurisdictions, and it's quite clear to me that mothers are being held accountable, and they're being held to standards that are much higher in relation to what fathers are expected to do. So in a way, you have to be a kind of ideal mother and make contact happen, even if you've been through domestic abuse. So we know, therefore, that these kinds of issues are incredibly difficult for family courts to deal with. And we also know, unfortunately, that the consequences of domestic abuse and effects on children in such cases are also misunderstood and underestimated by many judges, resulting in courts, and there's lots of examples of this all over the world, frequently giving abusive fathers unsupervised access to their children, despite the judge having made a finding that physical and/or sexual violence has occurred. And this has had catastrophic consequences in a number of countries, including the death of children where contact has been awarded to fathers with a violent history towards them, and women and children being placed, as the UN Rapporteur's report talks about, in gunpoint situations in some countries and being followed or threatened. And this is what I was talking about right at the beginning. The consequences are very, very serious if the family courts get this wrong. There is also evidence in the research literature of a general lack of knowledge on the dynamics of domestic abuse amongst justice system professionals, which reference the lack of education, training and continuing education in this area, leading to uncertainty amongst professionals in identifying the signs and dynamics of violence. And this is further perpetuated by fathers' rights organisations who have been involved in training judges, guardians and youth welfare workers, as indicated by the evidence in the UN Rapporteur's report on this. So we're seeing, unfortunately, patchy training, not good enough training, training being influenced by various lobbying groups, and also, I have to say, a huge lack of resources in this area. So even if you do get good professionals in the family justice system, they're often completely overwhelmed by the number of cases that they have to deal with. So that's a huge problem as well. And that is a problem also for the judiciary, who, when you talk to them, will say, that they just don't have the time to do justice to these cases because they just haven't got the resources to do it properly. In addition, many family source systems operate a gender-neutral approach to parenting and either mandate joint custody on separation and/or a presumption that requires displacement, which fails to recognise the gendered way in which family law systems operate. So, for example, in England and Wales, a statutory presumption was introduced that requires courts to consider that the involvement of both parents in their children's lives after divorce or separation is in the children's best interests, and I'm sure we'd all agree with that. However, there's evidence in the lower courts that we see consistently lawyers and judges applying it in cases where domestic abuse is present, and actually it's being used to add even further pressure on mothers to agree to contact which is damaging to children. Other systems impose an additional obligation on primary caregivers to facilitate contact. So Germany, for example, has incorporated a legal presumption that contact between both parents is generally in the best interest of the child, but goes further in adding a good conduct clause into the German civil code, according to which each parent must refrain from doing anything that impairs the child's relationship with the other parent. And parents must also promote a positive attitude on the part of the child towards contact with the other parent. However, we can see quite clearly how that could work against victims of domestic abuse in that any sign or lack of attachment tolerance which arises because of the violence may have an impact on the allocation of custody rights. So there's lots of examples of this from all over the world about how we can see again a prioritisation of communication and contact with the perpetrator and the father over concerns around safety, with some mothers in some areas of the world facing heavy fines and indeed imprisonment for failing to do so. Research has also demonstrated that the impetus to encourage shared parenting wherever possible too often trumps any legislative focus on the safety and well-being of the children. This issue is demonstrated in Denmark, according to the UN Rapporteur's report, where joint custody is awarded on divorce. However, mothers who are victims of domestic abuse are either deprived of visitation rights by perpetrator fathers or are forced to allow visitation by fathers who had committed domestic abuse, according to the NGOs that gave evidence to that report. Judges, it's argued there, are focused on future arrangements, erroneously regarding domestic abuse as historic and overly optimistic that past violence will stay in the past. And I've just completed this piece of research, and indeed that was very much what came through from the interviews that I held with judges and lawyers, this idea that it's historic. Well, anybody who knows anything about domestic violence knows that it's rarely historic, and the fact that it's historic does not necessarily mean that it's actually gone away. Numerous studies have also identified how a strong prioritisation of contact with non-resident fathers in family law proceedings has led to domestic abuse being marginalised, conflicting with a focus on protecting children from harm, even where there's proven domestic or indeed sexual abuse. And this pro-contact culture views mothers who refuse contact with parents as essentially hostile. And as a result, we can see how that works with the resurgence, or rather I should say, the formulation of parental alienation in these cases as a recognised tactic. This gendered nature of domestic abuse in family court applications, combined with this culture of no contact at all costs, therefore exacerbates the impact of so-called parental alienation. Parental alienation, you may have heard of it, you may not have heard of it, but there's no commonly accepted definition of parental alienation. And this is undoubtedly connected to the absence of robust scientific and empirical studies on how it is, what it is, whether it should be identified, whether it should be understood, etc. And the majority of them come from the US with, an understatement, methodological limitations at the very least. The problem is compounded by the fact that judges and professionals apply very different perceptions of what parental alienation actually is, and they show little understanding of the dynamics of domestic abuse and the impact of trauma on adult and child victims of abuse. And what's essentially happening here is that when a mother or a child says that contact is not a good idea or it's not safe, parental alienation is brought out as an explanation for why the child in particular is not wanting to see dad. And so these allegations are often used to demonstrate that it's not in the best interest of the child to award custody to her, and this is happening quite a lot in the US where it's particularly prevalent, and not facilitate contact between mother and child. And we've also seen, unfortunately, in the US, examples where if children are still not willing, children who are quite, teenagers are not willing, that they will be sent to parental reunification camps. And which sounds, yes, they are very strange, but yes, parental reunification camps. And the idea is that with the help of the psychologists at the camp, that you will eventually acknowledge that what you said was false, and then you get to return home to the father. And you can see how that is incredibly problematic. So parental alienation has been a real problem. This works particularly against victims of domestic abuse as a concept, because the evidence of alienation that's often used falls squarely within the range of expected reactions to abuse. So a reluctance to further contact due to fear and trauma on the part of the child and mother, and a strong desire for mothers to protect their children, apparently is evidence of parental alienation. And so the dynamic lays bare the essential contradiction between so-called alienating behaviours and the impact of domestic abuse. Protected mothers are therefore placed in an invidious position. If they insist on presenting evidence of domestic violence or child abuse to protect the children, they risk their efforts being categorised as attempts to alienate the children from the other parent, which could result in the loss of their care or contact with the child. And if they do not, they risk the safety of the children, as the court will make an order without any knowledge of the potential risks to the children. So we know that research has demonstrated that the use of parental alienation is highly gendered. One study in Canada found that out of the 357 cases studied, 41.5% involved assertions of domestic violence or child abuse. And in 76.8% of these cases, a parental alienation claim was advanced by the alleged perpetrator of domestic violence, with 65.4% of the claims being made by fathers against mothers. It also has a significant impact on custody outcomes. In the US, fathers' and mothers' rates of custody losses differ significantly when one or the other alleges alienation. It's actually used by victims of domestic abuse and perpetrators in the US because it is so ingrained in the system over there. Across all alienation cases, according to one recent study, when a father alleged a mother was alienating, custody was removed from her 44% of the time. When the genders were reversed, mothers took custody from fathers only 28% of the time. So as a result, when you're accused of alienation, mothers have twice the odds of losing custody compared to fathers. And this phenomenon, according to the academic involved, is leading to an estimated 58,000 children throughout the United States being placed into dangerous home environments annually. This is also alarming, as you can see, from the point of view of the child. Can we recall the UN Convention on the Rights of the Child at this point? Article 12 enshrines the rights of children to have their perspectives included and considered in legal proceedings that affect them. In the context of domestic abuse, listening to and responding to children's accounts of violence validates those experiences, and decisions should be better informed. However, a pervasive theme that emerges from the research literature in relation to children victims of domestic abuse is that a selective approach is taken to children's views based on whether those views accord with the prevailing pro-contact culture. And those views are more likely to be disregarded and discounted when they are opposed to contact, predominantly with fathers. So when custody decisions are made in favour of the alienated parent in this context, it's clear how the application of the theory undermines children's access to factors that support child resilience and protect children from lasting harm from negative family experiences. And it also directly contradicts with the best interest standard and constitutes potentially an infringement of the rights of the child to be listened to and to live in a safe and secure environment. Indeed, recently the UK Domestic Abuse Commissioner noted that there are several alarming cases whereby the primary carer has been accused of orchestrating a child exhibiting resistance, refusal and reluctance with a perpetrator non-resident parent, with many of these cases resulting in the child being removed from the primary carer, i.e. the mother, and compelled to reside with the perpetrator non-resident parent with whom they resist. In response to these mounting concerns, it has been removed as a concept by the World Health Organization from its international classification of diseases. The European Association of Psychotherapy considers it to be unsuitable for any psychotherapeutic practice. And in 2019, international human rights mechanisms dealing with violence against women and girls criticised the use of the concept of PA. And as a result, we've seen a number of European jurisdictions who have now made it very clear that parental alienation should not be used in any family justice proceedings. And we have a number of decisions from various Supreme Courts across Europe indicating the same principle. However, what we do know from the research, and my own research that's just finished, is that parental alienation hasn't gone away. It has been reformulated. We are now using different terminology, but essentially the concepts are still there and they are still pretty embedded. And what about the Hague Convention? Well, as I said earlier, it's supposed to cover child abduction. It provides this expeditious process, but again, the research that we have on this demonstrates that there is a gendered application of the Hague Convention. So as a result, as I said earlier, when mothers flee domestic abuse of their children across international boundaries, they become vulnerable to being treated as an abducting parent on top of this, under the Hague Convention, and there's clearly a gendered dimension to such cases. Recent research has demonstrated that around 3/4 of all cases filed under the Hague Convention are against mothers, most of whom, it is said, are fleeing domestic violence or seeking to protect their children from abuse. Now, we have this exception of the grave risk of harm. However, courts, and particularly Supreme Courts in lots of states, are reluctant to use that exception in favour of victims of domestic abuse and simply return the child to the state body for the courts there to decide the matter. And that's obviously less than ideal if one of the reasons that the victim is left is because she precisely has no faith or justice in the domestic legal system. So as a result, a number of women have been forced back due to baseless accusations of child abduction. Courts can, however, consider family and domestic violence when interpreting, as I said earlier. For example, the New Zealand Court of Appeals held that both the mother's history as a family and domestic violence survivor and her potential post-Hague future were pertinent to interpreting the grave risk exception, and it has subsequently declined to return a child in such a case. So it is possible for courts to do this. But as I say, until there's some real attempt to improve this in terms of the convention itself, it really is being left up to domestic courts in terms of how they interpret this particular exception. And what about human rights? And this is where a lot of my research comes in. Unfortunately, it's quite clear that they are largely absent at the domestic level. So I asked a question some time ago now, where are human rights? Is this actually happening on the ground? And the answer is actually no. So despite this lecture setting out the myriad ways in which human rights laws and standards are clearly relevant and have been held to be relevant by international legal mechanisms, there is little or no reference to human rights in cases involving domestic abuse before the family courts. And believe me, I've looked at quite a lot of them, particularly in the UK. And where there is, it's often a cursory reference to Article 8, which is the right to family life, which is what often a lot of people know about when they think about human rights in relation to family law, but zero reference to other rights, such as the right to be free from inhuman and degrading treatment as a victim of domestic violence, and the right to life, which is obviously implicated if you literally are fearing for your life when you're leaving the abuser. These rights are clearly implicated by experiences of domestic abuse and have been held to be implicated by various international and regional mechanisms, but it crucially requires the court to engage, if they're going to apply those, Article 2 and Article 3 in the European Convention's case, if they are going to apply those articles, they have to undertake a significant and serious risk assessment. And they also have to elevate the need for safeguarding over the right to family life. And that's exactly what isn't happening, unfortunately. My own research in the UK and 5 other jurisdictions in Europe has demonstrated also a clear reluctance on the part of legal stakeholders to use human rights, and a lack of knowledge amongst lawyers and judges, which is often to the detriment of victims of domestic abuse, most often women and children. So there's a reluctance, there's a lack of knowledge, and there's often this idea that human rights are kind of, the sort of last resort of the desperate, and we shouldn't really be using it. And actually, as I said, there's this huge toolbox, over here. Can we use it, please? And it's just not being used. However, there is one group which bucks the trend on this, and that's fathers. Where human rights are claimed, my research has demonstrated that they're predominantly claimed by fathers. And when they do, they are successfully used. We see fathers constantly, where they can do, talk about their right to family life with the child. We don't see mothers talking about their right to family life with the child. And we don't see children referring to their family life not to be with an abusive parent. So what we're seeing is too many cases as a result where contact and/or custody is being awarded to fathers who are also perpetrators of domestic abuse, even when it's a clear violation of human rights law and standards. And we're also seeing that those due diligence standards are not being employed by family law courts at the domestic level. As a result, the conclusion of this lecture is that there's little or no performativity of human rights when it comes to the rights of mothers and children, and that this represents a major implementation gap at the domestic level. And in that sense, the public-private divide with respect to victims of domestic abuse within the family justice process very much remains. Thank you very much.